Hello everybody, so welcome back to the English Law channel. Anyway, so carrying on with breach of duty, I want to think about professional defendants and standard practices. So one of the contentious issues that courts have to consider in deciding whether or not a defendant has met the requisite standard of the reasonable man in question is whether this defendant has acted in consonance with standard practice. So sometimes there's more than one way to skin a cat. Right, so if there's a cancer patient, an oncologist might say surgery, or the oncologist might say chemotherapy, even for the very same cancer. Two equally competent oncologists could recommend either path. One will say do this way, and the other will say no, do it that way. So the courts don't insist that one recommendation is correct and the other one is incorrect. But they simply say that the defendant must act in a way that be supported by a respectable body of medical opinion. And that's also contentious. What's respectable? I mean, how many doctors? The minority viewpoint, is that one okay? What if it's a small minority? What if only 20% of doctors would recommend that as against 80%? Is that still respectable or what? And how high status do these doctors have to be? There'd be professors? There'd be articles in medical journals? I don't know. So again, that is something which is debatable. So it's often said to be that the standard practice defence comes from the second limb of the Bolam test, and this is what was said in the case Bolam. A doctor is not guilty of negligence if he has acted in accordance with the practice accepted by a proper and responsible body of medical men skilled in that particular art. The doctor is not negligent merely because there is a body of opinion which takes a contrary view. Close quotation. Notably, it's the 1951 case, which is why they say medical men. All right, here's for the application of the the standard practice defence. White House against Jordan, 1981. The Court of Appeal noted that the implications of having an unreasonably high standard of care upon doctors would be grave. And the trial judge said there was a liability because severe brain damage was sustained, and the claimant, because the claimant suffered it. But on appeal, the evidence said this didn't prove the doctor had departed from standard practice, therefore there was no negligence. The House of Lords really emphasised that they certainly